Welcome to a Practice Pro CPD, brought to you by LAWPRO.
Good morning, everyone. I'm Joan Rutaic-Lang. I'm the Executive Director of the Toronto Lawyers Association, and I am happy to be involved in this wonderful partnership with LawPro. 3 times a year or 6 times a year, 3 times in the winter and 3 times, I guess, in the spring, we do a series of programs that are of interest both to uh, practicing lawyers and really benefit to LawPro as well, because they can communicate with you about the important issues they see. Today's topic is especially of interest for me, for the Toronto Lawyers Association, because we did a civility project. You'll hear all about it. And today's topic is professional civility. So it's wonderful to hear all of that. I just want to let you know that if you are interested in any other work that the Toronto Lawyers Association is doing, please check our website. We're excited about one program that we have coming up in December. We're all hearing more and more about neurodivergent people. Well, we have an autistic lawyer talking about how to work with your neurodivergent colleagues. It's available, it will be available online, and it'll be 1 hour of EDI, which is, I know, a bit of a challenge. So enjoy today's program, and hope to see you on one of the TLA programs. Over to you, Sean.
Thank you very much, Joan, and thank you to Deirdre and Precious and Sandra and everyone else involved with the TLA for partnering with us at LawPro to create these programs. My name is Sean Erker, and I am the legal writer and content manager at LawPro. And I'm speaking to you from Toronto, which is also where the offices of LawPro are, and the Toronto Lawyers Association. And I respectfully acknowledge that Toronto is on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples. It's now home to many First Nations, Inuit, and Métis peoples. Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Now, as this meeting is virtual, not all of us are gathered in the same place. And for many of you, this land acknowledgement is not the traditional territory that you are on. And so we invite you to take some time to learn about and acknowledge the traditional territory of where you live and where you inhabit at this time. One such resource you can look at is native-lands.ca to learn more about those. Now, I have a few housekeeping things to start with before we get into the bulk of the content. You'll see there is both a webinar chat and a Q&A function for this program offered through Zoom. In the webinar chat, you will find the program materials. If you don't see them, if you could just scroll up to the top of the chat, it was one of the first things posted. And that is a link to a PDF that contains all the materials for this program, including the TLA's report on professionalism and civility. Now, if you have questions, please put them in the Q&A box, different from the chat. So if you click on Q&A at the bottom of your screen, you can input the questions you have. We will be answering them at the end of the program, and we will be directing them to specific speakers. So if you want to hear more from any of the specific speakers that we have, we will try to address that at the end of the program. Now, we do have some very great speakers lined up today. First, we're going to hear from Idona Villa, who is a partner at BLG and is also a member of the board of the TLA. And she is going to speak to us about the TLA's report on civility and professionalism in the legal profession. What the origins of this report are, why it came about, what the concerns are in the profession about civility, and what the takeaways were from the research and the survey that was conducted to produce this report. Then we're going to hear from Catherine Shanny, who is claims counsel at LawPro. And Catherine is going to talk to us about, from LawPro's perspective, what the claims implications are for incivility in the profession. And by that, we mean certain conflicts that arise, actions that are taken that lead to cost consequences or negative outcomes for clients that can be traced to a lack of civility, lack of professionalism, or those kinds of problems, and our suggestions on how they can be best addressed moving forward. Then we're going to hear from Deborah Glatter, who is a legal educator and a management consultant. And Deborah is going to talk to us about civility with our colleagues within our offices, the people that we work directly with, and why sometimes we can be not as nice as we mean to be. And sometimes our colleagues can be not as nice as they mean to be, and that how we can best address those sorts of things and move forward. And then finally, we're going to hear from Sandra Forbes, who is a partner at Davies, and Sandra is going to talk to us about incivility between opposing counsel. So this is the kind of the crux that we like to think of in incivility when there is conflict and two lawyers start to take it, a bit too personally, a bit too far, and things get maybe a bit too heated. Because that's really why we're here today to talk about this. Our profession is in many ways founded on conflict. It's founded on resolving conflict between two different parties. It's founded on avoiding conflict between a client and other people in the future. And because there's so much conflict at the foundation, sometimes that can bleed through into the personal relationships, which is not good for our professional well-being, and it's also not good for the profession and outcome for clients. A couple other quick housekeeping things before I turn it over to Idona. Just a reminder, this program is good for 1.5 hours of professionalism CPD and the risk management credit with LAWPRO. And with that, I am going to hand this off to Idona. Thank you.
Thanks, Sean, and thank you everyone for joining this discussion today. To prime sort of the discussion for the time we have together, I've been tasked with telling you more about the Civility project that the TLA has undertaken. I've got to correct one one little update on my bio. I'm no longer on the board of the Toronto Lawyers Association. My term was over earlier this year, but I proudly serve as co-chair of the TLA membership committee. And in that role, along with Josh Kozabrovsky, who's co-chair with myself, this term, we, along with the members of the TLA membership committee and the TLA board, you heard from Joan earlier, our fearless executive director, the TLA really took to heart the importance of civility and really recommitting to the cause. And you might say, well, how did this perhaps project come about? In fairness, other associations have taken the cause and are very much doing very good work in the space. For TLA, this came about really as comments were percolating from our members in the context of lawyers migrating back to the office after the disruptions caused by the pandemic. And so in 2022 and earlier in 2023, our membership committee was hearing from members really talking about anecdotal evidence around this feeling, a palpable feeling of a decline in civility, that perhaps what we had experienced as people and professionals, the disruption caused by the way we work and engage with one another after the pandemic, had perhaps shifted the way we engage with one another, and that the comments we were hearing, this concern about the decline of civility in our profession, was something that was not particular to, say, civil litigators. We were hearing it from lawyers that were in the corporate transactional practice. Certainly, we're hearing it from civil litigators. We're hearing it not just from core members, and I'll tell you more about this, core members of the TLA practicing within Toronto, but just also outside of the GTA. And so what the TLA undertook was to actually try and study what was being reported to us anecdotally. So the TLA commissioned the TLA membership committee to really oversee the process. Jean Alexandris was actually engaged to assist the TLA with this. And what we did last year, we tried to gather as much data as possible. And I wouldn't sort of frame our study as an empirical study of sorts, with statistical significance analysis, for those of you that perhaps have done that in your academic journeys or professional journeys. But we set out to study this as professionals, based on the professional experiences lawyers were reporting to us. We issued a survey. This was in mid-2023. And the project, the data gathering exercise, really completed by the end of September last year. And it really consisted of a survey TLA members. We also had collaboration from other associations and various groups of lawyers that spread the news to their members. So we tried to have as a broad group as we could. And then after we did the survey, I'll tell you more about the survey constituents and that were able to respond. We also then engaged, we had facilitated sessions with two key groups. We had a facilitated session with judges, with the judiciary, and then we had a facilitated session with members of the bar. And we really attempted to get that in-person facilitated session with as broad of a group that we could get. So both litigators, in-house practitioners, corporate, private practice, lawyers that perhaps were looking at various aspects of the operational side of law, the business of law, mental health aspects of law and practicing. So we tried to have as broad of a group as we could. And with that, once we gathered that data, then we prepared the report that was issued in December of last year. You will have, I think Sean told me the report, and I didn't click on the link, but the report is in your program materials, and I think it's the beginning of those program materials. So I encourage you to take a look at it. In terms of the respondents, we had about 332 respondents provide us feedback as part of the survey. The report will give you fairly detailed statistics on the respondents, but just sort of some highlights for you. 41% of the respondents identified as male, about 48% of the respondents identified as female, 78% of the respondents completed their law degree in Ontario, and about 75% of the respondents identified as having completed their law degree internationally. We had good spread in terms of small firm, solo practice, mid-size, large firm respondents. So about 25% identified as hailing from a small firm, 23% from solo practice, 20% from mid-size, and 16% from a large firm. 12% of the respondents identified as having a disability, and 14% identified as a racialized lawyer. You'll see in the survey, and I won't read the results of every single question, but I wanted to highlight two. The respondents, the key stat for us that came out of the survey was that 70% of the respondents agreed that civility and professionalism in the legal profession had really suffered a decline. And about as much, 69%, about 70% reported that actually directly experiencing uncivil behavior. And I'm noting those statistics as for no coincidence other than to tell you what we've been up to in 2024 as a follow-up to this study. But we'll park those statistics for a moment. And in engaging then with facilitated sessions that we undertook with the judiciary and the members of the profession, the TLA really tried to put pen to paper everything we learned by engaging with the profession. And the reality is what we learned is civility is not a new concept. It is at the core of our profession. It's something that others in the profession have already done work on. We've struggled as a profession to define what civility means, but we all appear to agree that it is at the core of what we do. It is part of us maintaining the professionalism standards of our profession, and that it's important for us to commit to ensuring that civility doesn't erode in our profession. And so the TLA, you'll see, had a number of recommendations that came out of the report, short-term and long-term recommendations. And certainly for us, we took that to heart at the TLA. And so in going back to that statistic that I shared earlier, we just couldn't stop our work and say, all right, leave the fact that 70% of the respondents said they've noted a decline in civility and not do anything further about this. So we've continued to work with other organizations. We've worked with the LSO, LAWPRO, and spreading the word about what we learned from Toronto lawyers and lawyers outside of Toronto that were actually informing our work. And part of that, and I'm actually glad we're hosting yet another discussion today, and I really appreciate all of you making time out of your busy days to join this discussion, because the TLA now is engaging again with a profession. What we're doing this year is taking that statistic and saying, well, how do we solve for this? What can we do? So there was a number of themes that came out of those facilitated sessions. And one of the aspects that came out was a sense of how are we training the next generation of lawyers? The theme of mentorship came up. How are folks actually ensuring that this commitment to civility is passed on to lawyers as we train more lawyers? And even if you have folks that are early in the profession and or new to the profession, and lawyers that have been in the profession for 20, 30 years, how do you make sure that commitment continues? So we're engaging in 2 roundtables. As it happens, they're both occurring this month, one on October 21st and another one on October 28th. The October 21st panel is not panel, a roundtable is really focused at gathering feedback from general counsel and in-house counsel at various entities. And the thought there was that the lawyers that are engaging in advancing whatever cause they're advancing, be it in negotiations or in civil litigation, proceedings, they are advancing a cause based on instructions. And the thought there was that perhaps we ought to go at that group to see if we can find solutions in the way that we are perhaps handling matters, to again have this recommitment to civility. And the other group, October 28, is with managing partners of various law firms in Toronto. If you're here and you are a managing partner or have management responsibilities at your firm, and if you're an in-house lawyer and wish to engage with us, just please reach out. We'd be happy to include you in the roundtable to get a sense of your comments or otherwise even engage in discussion to get your feedback. We're interested to engage as an organization with members of the bar so that we have fulsome collection of views and feedback to inform our work. And the hope for the TLA is after we finish this secondary data gathering exercise, which Joan calls it sometimes Civility 2.0 for us at the TLA, we'll be producing a report similar in style to the report that we produced last year. And the focus will be on, again, driving to specific solutions. Sean, I'm not sure if you have other questions, but that would conclude my discussion about what we are doing in the TLA, subject to questions that you may have.
Well, thank you so much, Idona. If anyone in the audience has questions, they can put them in the Q&A box, and I will put them to Idona at the end of the program. But for now, thank you again, Idona. I'm going to pass it off to Catherine Shanny, who is going to lead us into a discussion about how incivility can impact malpractice claims. So, Catherine, I hand it over to you.
Thanks, Sean. Good morning, everyone. I'm here from your friendly liability insurer to discuss how incivility in practice can potentially lead to a claim against you and encouraging civility so that does not happen. And I'll be speaking with a focus on litigation today. Lawyers early on learn the importance of professionalism and civility as outlined in the Law Society's Rules of Professional Conduct and the Advocates Society's Principles of Civility. But as we all know, the rules become more of a gray area in practice, and advocating fiercely for a client can blur into sharp practice and incivility. And I'm going to be reading a couple of excerpts. The first one is Rule 7.22 of the Rules of Professional Conduct, and I quote, "A lawyer shall avoid sharp practice and shall not take advantage of or act without fair warning upon slips, irregularities, or mistakes on the part of other legal practitioners not going to the merits or involving the sacrifice of a client's rights." And the principles of civility and professionalism for advocates, and I quote again, Subject to the applicable rules of practice, advocates should not cause any default or dismissal to be entered without first notifying opposing counsel if the identity of opposing counsel is known. So today I'm going to provide some practical examples of incivility and sharp practice and how acting in this way could potentially lead to a claim. And incivility is often used by counsel as a strategic tool, and I would argue sometimes to their detriment. These methods often end up prolonging litigation, and they can include such things as, and I'm sure we've all encountered this before, threats to report you to the Law Society, service at the absolute last minute, unnecessarily aggressive letters to counsel, which we've all been on the receiving end of, not being flexible or accommodating with reasonable adjournment or scheduling requests as a result of illness, a death in the family, competing other actions, bringing unnecessary motions or refusing to consent on a motion that is very likely to be successful, and taking positions that are unsubstantiated by either the rules or the case law. And this type of behavior can often be triggered by client management or communication issues. And client communication errors are historically one of the largest sources of claims at LAWPRO year after year. And it's important to remember that you have been hired to provide a professional service based on your education and experience. And it's not for you to act in whatever manner the client wants you to, or to provide them with whatever answer they are looking for. So it's important to set client expectations from the very beginning of the relationship and continually manage those expectations with respect to not only results of the file or chances of success, but also your particular style and how the file is going to be managed. And it's always important to remember the hierarchy of duties. And it's first to the administration of justice and the rules of professional conduct, and then the client after those. And so I would say that fiercely advocating for your client does not mean that civility can or should be abandoned. Here are some issues that can arise from a client communication standpoint that could lead to incivility. A client sometimes asks or seeks or expects that a lawyer should be uncivil. And this can sometimes stem from a perception of how a lawyer should act or what a quote unquote good lawyer is from a non-lawyer perspective. And this, unfortunately can be influenced by television or movies. It's not realistic in practice, especially not in Canada. It can also stem from a failure of the lawyer to clearly explain the risks and costs implications of litigation or a file, realistically explaining the chances of success, or encouraging false hopes and setting unrealistically high expectations of the client. And this is true, especially with more challenging clients. A lawyer will really need to explain the consequences that could flow from being overly aggressive and unrealistic. And this can lead to situations where you end up jeopardizing a good settlement or refusing to settle and then losing a trial and experiencing cost consequences as a result of that. And you also need to be, I would say, especially mindful in situations where the client is either physically present if you're doing something in person, or present virtually by Zoom or otherwise. At discoveries, mediation, or trial, make sure to do ample prep with your clients beforehand, not only with respect to their own evidence that they're going to give, or the way that they're going to be cross-examined, but what to expect from the style of the other lawyer, and also from you and what your style is going to be. So it's not enough to just advise clients of consequences, but you also need to ensure that they meaningfully understand them and provide them with practical examples of those consequences. So in the jeopardizing settlement example, I would say that regardless of whether the client provided you with certain instructions, hopefully in writing, to be overly aggressive and not settle, this is, of course, in a situation where that may not make sense in the particular circumstances you are in. There is still a risk that that client could in future argue that you should have advised them to settle if the matter does not end up going their way in future. Another example is the way that you speak or treat other counsel or other parties at discoveries could potentially hurt you in a future refusals motion when a judge ends up actually reviewing that transcript. So, and finally, you're not only dealing with potential cost consequences at the end of the day to your client as a result of in that example, an unreasonably maintained position, but also potentially Rule 57 costs against you personally, depending on the severity of the behavior. Incivility ultimately comes back to the client, but then it could ultimately come back to the lawyer who made the recommendation to proceed a certain way, and that has to be kept in mind. I'm now going to go into a more detailed, practical example of incivility in noting in default and default judgment motion context, and how incivility or sharp practice could then lead to a potential claim against you. But the considerations that I'm going to discuss can apply to many other types of motions. Examples are the refusals motion that I talked about earlier, deemed admissions, a motion to validate late service or to allow for late service, especially in situations where that late service is very soon after the deadline, failing to file a statement of claim within 30 days of a notice of action. We have many claims about that as well. Again, when they're trying to deliver it very shortly after the 30-day deadline, setting aside an administrative dismissal order, a motion for a status hearing, a motion to extend the 3-hour time limit in the simplified procedure action for discovery, for oral discovery, especially in the context where there's an interpreter used, and we've all been there before, but there's many more examples as well. And I'm not saying that you should never oppose or bring certain motions when they are warranted, but it is important to consider if it is in fact warranted in the circumstances that you are in, or whether you are veering into incivility or sharp practice. So moving into the default judgment noting and default example, these types of motions can cause unnecessary delays in litigation and can lead to potential cost issues. And we're dealing with where a noting in default or default judgment just happens too quickly, or we're opposing a motion to set aside the noting in default judgment when knowing full well that that motion is likely to be successful. And at LAWPRO, we have seen many of these claims recently, and they usually involve lawyers either noting a party in default or moving for default judgment without sufficient notice. And ultimately, barring any egregious conduct or considerable delays by the defendant, a noting in default or default judgment will usually be set aside by the court. And courts do not look kindly upon a party causing unnecessary delays and racking up costs by aggressively noting a defendant in default without notice or in inappropriate circumstances. And so a few examples of those inappropriate circumstances are where the defendant has actually indicated an intention to bring a motion to strike, like a Rule 21 motion where a defense is not required, and then you necessitate a motion that you're going to be opposing when they indicated that they're going to strike anyway. Another example is where the defendant is self-represented but has indicated that they will be shortly retaining a lawyer, and obviously shortly you do have to follow up and continuously provide notice in that context. And a final example is where a lawyer has been retained now and indicated that they will be delivering a defense and giving them some time to do so without just noting them in default right away. And you may say, well, what are the practical ramifications of incivility or sharp practice here? Because at the end of the day, what you're doing is, you're only taking advantage of a failure of the opposing side to adhere to the deadlines imposed by the rules. And I mean, I would say if you bring a motion to note a party in default or to obtain default judgment, and either is set aside by defense counsel due to lack of notice, insufficient notice, or for other reasons, there is some risk that costs may be awarded against your client on a full or substantial indemnity basis. And you then face the risk of a claim by your client for these costs. And in some cases, costs could be potentially awarded against you personally under Rule 57.07 of the Rules of Civil Procedure. I'm going to discuss two decisions that outline this issue. The first is a 2020 decision, and the cost decision is actually unreported and is included in the program materials. But the JPW Niagara Limited decision ultimately did away with the almost certainty in the case law before then that the party seeking the indulgence would have to pay costs even if successful. And this is in the context of a motion to set aside an administrative dismissal order. And it's Justice Sweeney, and I quote, "The general rule that costs are awarded to a successful party is not displaced because the plaintiff seeks to set aside an administrative dismissal order. A blanket assertion that a plaintiff, or indeed any party, is not entitled to costs if that party seeks the court's indulgence is not consistent with the general principles of costs. It does not discourage litigation. It does not encourage resolution. It allows responding parties to take unreasonable positions because there's no risks of costs being awarded against them. There is no general rule that a party seeking an indulgence is not entitled to costs, nor should there be. The issue of costs is an exercise of discretion." A second decision that I'll be discussing is BPR Litigation Lawyers and Globodex Financial Corp. And this is a 2022 Superior Court decision. And I believe a link is also in the program materials of this decision. And Justice McCarthy, in the context of a noting in default, the plaintiffs noted the defendants in default despite knowing that they were going to move to strike the statement of claim. And the plaintiffs ultimately resisted a motion to set aside the noting in default, but ended up capitulating after 15 months. And the defendants pursued their costs and were ultimately awarded approximately $72,000 in costs. And the court held, and I'm quoting, "Our courts have consistently held that substantial or full indemnity costs may be awarded against a plaintiff taking inappropriate default steps when a party clearly intends to defend the proceedings and was taking steps to bring a motion to strike the plaintiff's proceedings." So, even though you are technically adhering to the rules of civil procedure and what they allow you to do, acting in this way may not be the best decision for you or your client. And bringing such motions can also result in opposing counsel refusing to give you indulgences in future, thereby prejudicing your clients, and again, potentially leading to a claim against you. And as I said earlier, this can be said for any type of motion. The best practice at the end of the day is to be reasonable, to set deadlines well in advance of noting a party in default, and before considering such a motion, to agree to a timetable on consent or bring a motion to set a timetable, and potentially consider bringing a motion at some point if that timetable is breached and with adequate notice. And I will finally move on to everyone's favorite topic, coverage considerations. And there are coverage considerations of engaging in civility or sharp practice. The nature of your conduct in the underlying litigation will determine the extent to which you will be indemnified for costs awarded against your client under the policy. And the court's findings with respect to that behavior could potentially put your coverage outside, your conduct outside of coverage. So for instance, it could be arguable that the conduct was malicious in nature, which then you're facing exclusion under Exclusion A of the policy. There are cost awards that amount to a penalty sanctioning a lawyer's behavior, and that can also not attract coverage. The policy ultimately only covers costs that are compensatory in nature and excludes cost awards amounting to penalties as a result of a lawyer's conduct. Another example is unnecessary fees paid by your client for these kinds of motions, causing unnecessary delays. This can result in fee disputes, which are not covered under the policy, and which can then potentially lead to a claim where the client argues that they should either have not had to pay certain fees or want the return of fees, and they allege negligence to get those fees back. It's also possible, finally, that a client could pursue you for fees incurred as a result of having to consult with independent legal counsel. So at the end of the day, not only can incivility in the profession lead to, a decline of public respect of the profession or issues in the profession itself, but it can have real practical implications for your clients and for yourselves. And finally, as a LAWPRO plug, if you become aware of an error or potential error, please report it immediately, regardless of whether or not you believe that a mistake has in fact been made. Your deductible is not automatically triggered as soon as you report. And the sooner you report, the better, so that your insurance will be there when you need it. And we are very friendly. Thank you very much.
Thanks so much, Catherine. I'm going to invite Deborah Glatter to join us now to talk about incivility between colleagues working together. So people within the office, people that are working as partners or associates. And just one more reminder, if you have questions for any of the speakers, you can click on the Q&A button at the bottom of your screen, bottom of the Zoom screen, and type that question into the Q&A, and we will put them to the speakers at the end of the program. But Deborah, I hand it over to you.
Thank you, Sean. And I'm going to try very hard to share my screen now. And there we go. All right, here we go. And folks, you're going to get this PowerPoint presentation at the end. If there's anything there that's of interest to you, you're going to have it. There are a few references to articles and things like that you might want to do a deep dive into. All right. So here's what I'm going to be talking about over the next 15 minutes or so. A candle problem that I'm going to show you now, and I will give you the answer at the end of my 20 minutes. It's my trick to make you stay engaged with me through the entire time we're together. And then a fact situation showing a pretty typical interaction in a law office and how things can go awry. The next thing I'm going to talk about, emotional contagion, fundamental attribution error, and the horns and halo effect, why things often go awry that needn't in a law office, what led to the problems in the fact situation, what can we do about it? And then a quick overview of what the structure of a civil conversation looks like. And then if you're still with me at the end, you get the answer to the problem if you haven't already solved it. Here we go. All right, so this is an experiment out of the University of Maryland. And what they did was to induce a positive, pleasant, civil atmosphere with one group. They had them watch a comedy film. Then in group B, they wanted to induce a negative atmosphere. They showed those folks a concentration camp documentary. Then they gave both groups a problem to solve, Carl Dunker's candle problem. So each group got the text that you see in this picture, a candle, and a book of matches. And their job was to attach the candle to the wall so that it didn't drip on the floor. The table doesn't count for the purposes of this experiment. And not surprisingly, the folks who were in a pleasant mood because they had been in a civil, upbeat environment were able to solve the problem more quickly than group B. So what I'm suggesting to you is in your law offices, to the extent that you can keep a civil atmosphere, pleasant atmosphere, and I know that's often hard given the stress and strain that lawyers are under, but it does allow for better cognition, problem solving by the folks around you. So if you're trying to get the job done, keep a civil atmosphere. This is Adam Grant. If you're on LinkedIn and you don't follow him, I suggest you do. Grant is a psychologist at Wharton at the University of Pennsylvania. And he often posts pithy things like this that kind of nail the issue. For those of you who are listening in your car, I'll read this aloud. Disrespect doesn't just make people feel bad, it leads them to perform worse. Here's evidence from medical teams. Even a single insult decreases the quality of diagnosis and procedures. Rudeness disrupts focus and undermines collaboration. Civility is not optional, it's vital. And I guess the message to all of us here is make sure that your doctor or surgeon is polite and nice to the folks around them, given what Grant's experiment shows here. So now we're moving into the second part on the agenda, a quick fact situation in which I'm playing a partner in a law firm. I've got a great associate. Her name is Halo. She's an A+ associate. And then I've got Billy, who I would rank as like barely a C associate. He's not, in my view, very good. And my client is Clara. Here's what's happening next week. We've got a trial going on. There's a witness prep meeting that went on this morning. At that meeting was the witness, Halo, my A+ terrific associate, and my client, Clara. Who wasn't at that meeting? Billy, the fellow that I think is a C associate at best. So then I get this email from Clara, and the subject line is unreliable associate. Waited for Billy to show up at the witness prep meeting. Finally called him. He was abrupt. He claimed to know nothing about the meeting and spoke to me in a raised voice. And then in bold, uppercase, 3 exclamation points, not impressed. We've got a very upset client here. I've just read this. I'm now upset, obviously. So I shoot off an email to Billy saying, see that email from Clara below? I can't believe you missed this meeting. This is a serious problem. Uppercase, in bold. Billy is now an unhappy camper and quaking in his boots, I suspect. But I get this email back from Billy saying, you said that fees were becoming an issue, so cut back where possible. Because Halo was going to the meeting, I didn't go. When Clara called, I was in the food court. It was crowded and it was loud. I didn't tell her I didn't know about the meeting. I said I didn't know I was supposed to be at the meeting. It was loud, so I had to raise my voice to be heard. Clara misheard me. I dropped the ball here. This is the next piece on the agenda that I spoke of earlier. What went wrong here? 3 things: emotional contagion, fundamental attribution error, and the horns and halo effect. Let's talk about emotional contagion. It's the tendency to mirror behavior. So when opposing counsel is rude to us, when our client is upset with us, it's very easy for us to mirror that behavior. Instead of emotional contagion, I, as an adult, should have been experiencing emotional regulation. I'm an adult. I need to be able to control myself in this environment, especially knowing what I talked about earlier, that me being as upset as Clara and voicing that throughout the office is going to have everybody walking on eggshells. Productivity is going to decline. That's not the way to go. I want you to think about Apollo 13 and Jim Lovell's famous comment to NASA when, I'm sure he was very upset thinking that the spaceship was going to explode, but instead of screaming out, "What the heck's happening here? Somebody help me." NASA trains its astronauts and everybody else on the ground as well to work the problem. And in order to do that, people have to have emotional regulation. So as a result of that, we hear Jim Lovell saying, Houston, we've had a problem. Very level. I don't know if any of you saw the movie The Martian. Jessica Chastain was the commander, and she speaks throughout that whole movie with what I think psychologists would refer to as flatness of affect throughout, just keeping everybody calm the way NASA trains astronauts. She's the commander. She doesn't have the luxury of showing her obvious upset at having left Matt Damon on Mars. So I suggest to all of you in your offices, be the commander, be an astronaut, keep your tone civil, watch out for emotional contagion. Instead, go for emotional regulation. Let's go back to Psych 101 in our university days. Fundamental attribution error. That's the tendency to overestimate the effect of personality and underestimate the effect of the situation in explaining behavior. So we think that Billy, or I thought that Billy's bad behavior, his irresponsibility at not showing up at the client meeting, the witness prep, related to a flaw in his personality rather than the situation. And of course, the situation was a lack of communication here. I wasn't explicit in my instructions to him when I said cut costs. I should have communicated to him, yes, cut costs, but check in with me first before you do that so I can okay it, as opposed to just leaving it up to him to decide. So fundamental attribution error here is me just, deciding that Billy is irresponsible as opposed to the situation. I often think in law firms, George Bernard Shaw's comment, the single biggest problem in communication is the illusion that it's taken place. And I think that applies in this scenario. The other thing that I'm guilty of is what psychologist Edward Thorndike called the horns and halo effect. And that was something he noticed in the military, that when asking officers to evaluate soldiers on traits such as intellect, leadership, if you rate a soldier highly in one area, the soldier tends to be rated highly in all areas. So it's the halo effect if you think somebody's great, the horns effect if you think they're not. In the fact situation I just presented, had Halo not shown up, that's the A+ associate, had she not shown up at the witness prep meeting, I probably would have been worried. Oh gosh, Halo, she's my star associate. Something must have happened. I hope she's okay. But it was Billy, who I've already tainted with horns and thought, irresponsible guy. So we tend to get in our own way when we're dealing with our colleagues by classifying them in one group or another and not necessarily seeing incidents as separate and not necessarily falling into the category. In this case, I should have given Billy a bit of the benefit of the doubt. So you want to beware of emotional contagion. Don't have everybody around you walking on eggshells. Practice emotional regulation instead. We're adults here. fundamental attribution error. Don't be so sure it's a personality flaw. It might be the situation. And the horns and halo effect, where we just categorize people, and once we've written somebody off, we've written them off. All right. Here's a simple structure to have a civil conversation. Instead of saying, Billy, where were you at the meeting? You dropped the ball again. You didn't show up. Use I words instead. Stick to the facts. Name calling, using adjectives, that sort of stuff doesn't help. Be curious, what happened here? And future focused. What does that look like? So instead of saying to Billy, you did this, you did that, I'm going to use I. I got this email from Clara. I'm concerned about it. I'm going to state facts. I can see from the email she's obviously upset. And I think this is really where most of us drop the ball. Come to this situation with curiosity. What happened here, Billy? Can we have a discussion, a conversation? And then future focus. Okay, how can we avoid this in the future? And if Billy's being honest with me, he's saying, well, Deborah, it would have certainly helped if you were more explicit in your instructions and tagged on to not just watch the fees here, but can you check in with me when you decide, where you're going to cut fees? So simple structure to a civil conversation. Don't use I, use you. Don't use you. People get defensive. Use I. State facts. Come to it with a curious mindset. And then think about, have a conversation. How can we avoid this in the future? Now, thank you for sticking around towards the end of my comments. And here's the answer. People don't think to use the box. They think about the tacks, the matches, and the candle. But as you can see from the picture, they've affixed the box to the wall, stuck the candle in the box, and it doesn't drip on the floor. Thank you very much for your time and attention.
Thank you so much, Deborah. Just as a reminder, this program will be available to watch online at practicepro.ca/CPD at the page for this particular program. And just like all of our previous programs are available to watch at practicepro.ca/CPD. And Deborah's PowerPoint presentation specifically will be available on that page to download and view again after this program has ended. I'm now going to turn it over to Sandra Forbes, who is going to finish off our presentations today with a discussion about incivility between opposing counsel or colleagues who not necessarily in the work environment. And Sandra, I hand it off to you.
You think by now I would know to go off mute after 4 years. Thank you, Sean, and thank you for inviting me to join this discussion. Civility is a critical value for all of us, whether we're litigators or not. And it's because the only asset that we really have is our reputation. And we work so hard for such a long period of time to develop that reputation. When you think about it, it's just so easy to lose it. I commend the TLA for taking on the issue and embarking on the work that led to the 2023 report. I think half the battle is making people aware of the issues and having a discussion with them, and the report certainly does that. So I was asked to say a few things about civility in dealing with opposing counsel and also just during dispute resolution in general. And I'm actually going to try not to use all of my allocated 20 minutes so that there is time for discussion and questions, because I see that we've gotten quite a few questions. And I think some of the comments that I have will mesh very nicely with what we've already heard from Catherine and Deborah's excellent presentations. So I think you have to start with the reality that frames this discussion. And what I mean really is the reality that we face as lawyers today. If we don't recognize that, we can't have a useful discussion about civility or professionalism. And the way I envisage the situation is that our conduct in the courtroom and vis-a-vis opposing counsel has really been inevitably affected by 4 interrelated transformational events. The first, just broadly, the electronic age. It's the world now where we send off really quick emails rather than considered letters. And where, in a large portion of our cases, discovery is such an enormous exercise that it becomes very expensive and easy to use as a delay tactic or in some kind of abusive a way. How many people in this webinar remember the day where you would respond to a letter by sending a fax and usually could assume you had 1-2 days a week before you even had to think about the file? How many people remember the day when you could walk into an examination for discovery with 1 binder containing the documents produced in the case? I think probably very few. And that change, I think, has had serious effects on how we deal with each other. The second, I would say, we're now in this post-COVID era. And I know there's a lot of good things about Zoom and Teams, but there are also a lot of bad things about it. And to me, the most negative part of it is that the adoption by our courts of virtual hearings and by counsel of Zoom or Teams or whatever you use has replaced us getting together in person. And that has affected our relationships. Third, this is maybe not that new, but it's getting worse. It's the fact that, you know, the cost of litigation is beyond the means of 99% of Canadians. And that means that most cases don't get to the courtroom door. And as counsel, we see each other and interact in person less and less. And when we do square off in the courtroom, the stakes just seem higher, and that puts more pressure on us. And lastly, you know, society in general is plagued right now with a lack of civil discourse. I mean, we can look to our friends in the South for some really extreme examples, but it's also happening in Canada, and it affects us all. So with that, let me just make a few comments that hopefully you'll find helpful, even if just to elicit discussion about these topics. So whatever form of law you practice, you're an advocate. I mean, we're all advocates. We just do it in a different forum. Some of us in the courtroom, some in a boardroom, some over the phone or on video. And if you boil it down, what we're really doing as lawyers is trying to get to a certain result. And that always involves advocacy, whether formal or informal. And advocacy is all about persuasion. And the question we're always asking ourselves, regardless of what type of law we practice, is how best can I persuade the other side, whether it's the lawyer you're negotiating a contract with, that a certain clause is an appropriate one, or the judge, convincing the judge that the equities are on your side of the case. But what is not persuasive is uncivil conduct. I mean, it turns people off. And people who are turned off stop listening. It's a natural human trait. And when people stop listening to you, you have lost the ability to persuade. As my spouse sometimes says to me, and I hope it's in jest, I'm not so sure, I hear you, but I am not listening. That is the reaction you get when you are uncivil to counsel on the other side. And don't kid yourself. I mean, judges know when there is incivility amongst counsel in their courtroom. I mean, either their registrar tells them about the bickering that happened in the courtroom before the judge entered, or it's pretty obvious from the body language or the apparent tension in the room. And I'm sure all of you have friends who are judges or have been to seminars where judges have spoken and have heard this many, many times. The last thing judges want to do is to adjudicate disputes between counsel that are not relevant to resolving the substantive issues in the case. For example, things like complaints about the late delivery of a factum, or, you know, handing up a new case right before the motion starts, or, you know, disputes about how you divide up the time you have for a hearing. You know, judges want to be helped. If your submissions don't help them resolve the substantive issues, they don't want to hear them. And forcing the judge to become embroiled in this kind of stuff uses up, you know, the gas in the tank of persuasion. And it's not going to advance your cause at all. So let me just take one example of a situation, how you might handle it. you're the moving party and you're about to stand up to present your submissions on the motion, and the other side hands you a new case. You haven't had time to look at it. You have no idea if it changes your position, if it's relevant, if it's irrelevant. I mean, it's obviously super annoying that it's happened, but what you don't want to do is get up and start complaining in front of the judge about it, because the judge just wants to be helped. And if that case is relevant, they're going to want to hear about it. So, an appropriate way to deal with it is I can think of two options to say, before I begin, my friend has handed me a new authority just a few moments ago. I haven't had a chance to review it. And I wanted you to be aware of that, Justice Smith, and I will deal with it in reply. Or if you think you're worried it might change the focus of your submissions, say that just in a slightly different way and ask for a 10-minute recess so you have a chance to read the case and take it into account in your submissions. Either way, a submission based on you trying to help the judge and not just simply complaining about counsel's conduct is going to go much farther and be more effective. Judges expect counsel to work through those types of issues, and if we don't, it just negatively affects our reputation before that judge and other judges, because judges talk. And if you've negatively affected your reputation, you've hurt your ability to persuade. Example that is talked about a lot is, a counsel refusing to agree to an adjournment request that has zero effect on their client's substantive interests. And, some counsel think they're doing that. They're playing hardball. They're showing they're really tough, but nothing good comes out of that. There is no positive consequence from rejecting an adjournment request that doesn't substantively affect your client. It only has negative consequences. It harms your reputation with opposing counsel, and not just in that case, but in other cases, because people talk to their friends. And if you get a reputation as an unreasonable counsel or somebody who can't be trusted to deal with things in the appropriate way, that actually negatively affects your ability to represent your client's interest in that case and in future cases. You harm your reputation with the judge who has to resolve the issue. And I always see that situation as a lost opportunity, because you know what? Tomorrow you might need a break. You might need an extra day for your factum. You might need a brief adjournment for a personal matter. And if you have been unreasonable, how could you expect people to be reasonable with you? So it's good to have that goodwill in the bank. So this all sounds really good in theory, and I'm probably preaching to the converted with the people on this webinar. But how do we navigate all this stuff? How do we achieve this in practice? Well, we have an obligation to zealously represent our clients' interests within the limits of the law and in accordance with our obligations to be civil and professional. But what do we do if uncivil behavior is affecting our ability to represent our clients? Or what if our client is representing us to be difficult in an unconstructive way? So I have some general guidelines, or my mantras, that I'll share with you. And then we can talk about maybe just two specific examples and then open things up for questions to all the panelists. General guidelines: 1, don't take it personally. 99.9% of the time, it's not personal. And if you don't take it personally, it keeps the emotion out of it. And emotion just complicates things. So don't take it personally. Second, take the high road. Always take the high road. You will never regret it. You will be super annoyed that you can't get into the trenches to fight, but taking the high road is always going to work out better. Don't descend to the level of the conduct directed at you or your client. As my friend from Nashville always says, don't get drawn into the swamp. You'll just drown. And I think probably most importantly, think before you react. I call it the 24-hour rule, but you might not have 24 hours. It's whatever time you want to put into that representation of the rule. You get that really snarky letter or email or whatever, and you immediately want to respond. That's your human reaction. But what I do is I kind of do respond in the way that makes me feel good, and then I let it sit. And I always change that response and take out the more aggressive part of it, and live by my mantras, because I always ask myself, if that went before a judge, would I be okay with it? And if I even pause to think about that, then I realize that the correspondence is not appropriate and has to be tailored to being more civil and more professional, even if it's responding to something that is over and above in terms of incivility. And remember, the end game is to get the right result for your client. You don't get paid because you win the battle of the letters with opposing counsel. You get paid because you represent your client to the best of your ability and you get them a result that is appropriate in the circumstances. So what do you do when you have an abusive person on the other side or an uncivil person? Well, I mean, it's problem, I guess, is there's no one size solution that fits all. It depends on the case. It depends on the person. It depends on the issue. But a couple of things to keep in mind. Listening. I think listening goes a long way with people. There's a lot of truth in the theory. I find that people just want to be heard. And if they feel you're cutting them off or you're not listening or you don't respect them, it sets them off and causes the uncivil behavior or exacerbates it. So listen, even if it's outrageous, listen. Show empathy, even if you disagree. Let's say you act for the defendant and you get a super nasty letter in response to your offer to settle to the plaintiff. And this is a plaintiff that feels very hard done by. You disagree with their claim against your client, but you recognize their feelings. You've got to respond to that letter in the right way, knowing who your audience is, not just the lawyer on the other side, but their client. And you can respond in a way that shows empathy at the same time as responding with the substantive reasons as to why your offer is more than reasonable. You don't have to, delve into the swamp, so to speak. Pick up the phone, get to know the person on the other side, develop a rapport, avoid the multiple back and forth emails that are just annoying. You can always, and you should, as Catherine set out, confirm where you got to in an email or a letter later. But my experience, and you may have had different ones, is that people find it harder to be uncivil in person, and I include on the phone in that, than in writing. And it's also easier to be uncivil to a person you don't really know. So get to know your colleagues and develop a rapport. And, there is going to be that rare case where the correspondence and the discussions, you can't turn them around and they continue to be abusive. And you may get to the stage where you feel you can't speak to that lawyer. You have to do everything in writing. But that's a last resort. And hopefully you don't have those cases too often. But still, those communications, even if written, you should apply the same filters. Would you be happy with it going before a judge? Is it focused on the substantive issues and not wading into the swamp of the allegations that really don't have to be addressed? So lastly, what about clients who are difficult? The client who wants you to play hardball, be aggressive. Trying to think of the aggressive lawyers on TV. I can't actually, because most of them are like Matlock, I'm showing my age, are gentlemen. But everybody has a different style and approach. And don't be something that you're not, because it never works. But following on what Catherine said about your role as counsel and what it's not, I think this really comes down to educating your client right at the beginning of the relationship and helping them understand what their role and what your role is. So there is a great editorial. I tried to find it for this session, but it's so old I couldn't. There's a great editorial in the Advocate Society Journal by David Stockwood when he was the editor. So this is a number of decades ago. And it's a little short article, but it's discusses what the role of the client is and what your role as counsel is. In a nutshell, he says, the client's job is to tell you what they want and the risks they're prepared to take to get there. And your job is to figure out how to get there. So the client gives you the destination and how much they want to spend, and you drive the bus. And David would say, don't let the client be a backseat driver. And I think that is very good advice. So you have to educate the client and you have to start the relationship on the right foot. And so a client should be educated in the appropriate way that they're not able to give you unreasonable instructions about things like adjournment requests or scheduling, etc. but they need to be educated on that. And I think that's something that all of us kind of fall down on because we don't necessarily think about it when we start the relationship. So how do you respond to the client who says, you're not being aggressive enough, you know? And I think the women in the audience, I experience this. I get this much more, I think, than some of my male colleagues, because my style is not, I think I'm firm, but I'm not a super aggressive person in the way I present myself, either in court or in letters or whatever. So I think women get this, I think, quite a bit more than men. Well, there's no one size fits all. But what I try to do again is refocus the discussion with the client. And so let's just take a hypothetical. There you send a proposed schedule to the other side, and the letter you get back is inflammatory. It's accusing you of trying to delay so your client can continue this reprehensible conduct. And just think of all the things that are in the letter that are just objectionable. And the client is super angry about this and wants you to blast back and really go, you know, hard hitting at the conduct of the lawyer on the other side and the client and blah, 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 blah. So my advice in that situation, hopefully you don't get there because you've sort of managed the client, but let's say you are in this situation, you got to stay focused. And that's what I say to the client, stay focused on what the end game is. Letters like one we just got, it hurts the sender way more than it hurts us. I know you're annoyed, but that should be neither here nor there. We're going to be in front of a judge and we want to position ourselves in the best way. So we are going to respond civilly to the substantive parts of that letter and just disagree politely with their unjustified comments, but we're not wading into the swamp. And, you know, following on from what Catherine said, litigating the merits of the case by letters, it's very expensive and it gets you nowhere. So let's use our limited resources to actually fight the merits of this case and not get distracted by this, you know, irrelevant abusive conduct, and let's not let it affect our strategy. I mean, usually that works, but it's a bit of a dialogue with the client and it's something that you have to work with. So I'm going to end my remarks there. The one thing I would say is I was reminded when I was preparing for this that the Advocate Society has the principles of civility and professionalism. You can get them off their website. And they actually are helpful because they give some sort of examples of things that we normally face and some suggestions about how to deal with them, because there's also a best practices part of it. So, and it's not long. So if you are looking for some guidance, it's certainly a good resource. So thank you very much for your attention.
Thank you, Sandra. That was wonderful. And actually, the Advocate Society's principles are included in the program materials as well.
Great.
So if you can go into the chat and scroll up, if you don't see the link to the materials, it was reposted a few times and it should be at the very top if you are looking to find it. They can also be found on practicepro.ca/CPD at the webpage for this particular program. Now, we do have some time for questions. So if you have any additional questions, now is the time to put them in the Q&A box, which is a button at the bottom of your screen, and we will be able to direct them to the speakers. A couple of housekeeping things before we do the questions, though. This is part of our ongoing Thursday tip series with the TLA, and we usually do 6 of these a year, 3 in the spring and 3 in the fall. Our next program is going to be held on November 7th, and that is on what we're calling the 3 M's of building your practice. So that's marketing, management, and mentorship. So it's the things that they don't teach you in law school, but you need to know in order to build up your practice, whether you're a sole practitioner or whether you are looking to take on a leadership position or already have a leadership position in your firm. These are some key skills, and we're really excited about this program. This program and all our other programs are also available online at practicepro.ca/CPD. There will be a survey in the chat function that the TLA is going to post momentarily here. Please give that a click, take the survey, and let us know what kind of content you want in the future, because it helps us develop this program. So for the questions, I want to call up Catherine again here, because we have a few questions that build on what Catherine was saying earlier in the program. So Catherine, I'm just going to read out this question to you. It reads, the person wrote, in a recent matter, I faced very obstructionist counsel And on successful conclusion of the action, which was by summary judgment, I asked the court to award costs against counsel under Rule 57. I was not only denied, but my client was ordered to pay costs for that portion of the appearance that dealt with costs. When have you seen costs against the solicitor be successful, or what kind of conduct do you think justifies such a request?
Yeah, I mean, it's difficult to say. It's very, very contextual and fact specific. I will say that the amount of costs at issue is probably a really big factor in it. So if the conduct is so not only egregious, but has caused so much delay in the proceeding that you face, cost consequences of, hundreds of thousands of dollars against a client or that the court has to deal with, I think the court is much more likely to consider awarding costs against the lawyer personally. It's sort of, are there multiple motions? Are there, there's things in the affidavit that are just so, scandalous, vexatious? Are there things in the pleadings? So it's not only unnecessarily prolonging the litigation, adding additional motions, creating such sort of inordinate delay and displaying such behavior that it creates a situation for your client and for the other side. So I think that those are likely to be the main factors, but the amount of delay and the amount of costs, I think, is probably going to be the main two. So I'm not sure about in this specific example why the court declined to award costs, but it might have not gotten to that extreme point, because it is an extreme form of relief. It shouldn't be taken lightly by the courts. So yeah, that's what I would say.
Thanks, Catherine. And one more question for you, Catherine. If counsel discovers a mistake that may be prejudicial to their client, and it appears opposing counsel is taking advantage of this, how can counsel manage the error with the opposing counsel, and at what point should counsel contact LAWPRO?
Yeah, so we in my noting in default and default judgment example, and I'm sure everybody here has been in this situation before where you're a day late and you find out that you contact the court and find out that you've been put in this position, and counsel is sort of hemming and hawing about whether they're going to consent, knowing full well that if a motion is brought, it's going to be set aside. Contact LawPro as soon as you find out or recognize the error, even before any other, either the client or the other side recognizes the error or finds out about the error. As I said, your deductible does not get triggered as soon as you contact us, and we may be able to help you manage it and sort of helping you with discussions with counsel, what to say, sort of what case law maybe to put forward. Maybe they will consent sort of quickly, and then we can close the file at that point. So I would say as soon as you discover that there is something that could potentially lead to, there's a negligence issue, report it right away. We can help.
Thanks, Catherine. Next, I want to put a question to Idona Villa. So Idona, if you can turn your camera on, I have a question phrased for you. Has the study that the TLA done and the research and the report that was produced, was there any correlation found between the mode of communication and incivility? And the example given is, could the proclivity to use email and text messaging, especially in our remote work environment that we're all in now, instead of a phone call or instead of in-person meetings, has that been found to lead to any increased incivility? And the questioner asked, a recent US study of 2023 found that corporations and professional service organizations indicated that a huge percentage of the most recent hires were dismissed because of poor communication skills and a lack of professionalism that stemmed from that. So that's an example of what they're talking about.
Yeah, thanks for the question. We didn't specifically sort of study it on the survey in terms of a correlation, but it did come up in discussions with the profession as our modes of communications have certainly changed, and there's perhaps also a preference sometimes for email. I'm noticing certainly myself in my files. I'm still old school and sort of draft emails to opposing counsel and prefer to send a letter and attach it to an email because I think that it's going to be used in a motion record someday. But I am noticing more and more, certainly in the last 5 years, a tendency to write to one another as if you're texting. And you're doing that with opposing counsel and sort of these one-liners, and they're quick, and it's sort of this back and forth that I think the mode of communication sort of allows for that. And I would have to say that while the feedback we got certainly was a focus perhaps and a recommitment to engaging with one another, perhaps you get that new file or you have a new matter where you can literally just pick up the phone and talk to the other side, as opposed to sending an email and saying, hey, I'm so and so and I've just been appointed to, represent so and so. And the feedback we got is certainly the focus on those in communication, phone versus an email, might actually set the tone for the file. And it's so no direct sort of studying of the correlation, but more anecdotal feedback in the consultation that certainly appears to be a factor in that may help with civility or may not, depending on the chosen method.
Okay, thank you, Adona. I have a couple questions here for Deborah, actually. So if Deborah could turn on her camera, I would like to put a couple of these questions to you, as I'm sure you will expertly answer them. The first one is a question about civility when it comes to ethical breakdowns within an office. So this person asks, what would be the best course of conduct in this kind of a situation where they have a senior lawyer, a supervisor, or a boss that hands off a client to them, and in the review of the materials, they find that there was some misleading conduct done by the previous lawyer, their boss essentially. There was some mistakes that were made, and when they tried to address this, there may have been some suggestions from senior lawyers to engage in unprofessional conduct to resolve it. And how do they best resolve those kinds of conflicts within an office when they feel like there are ethical questions?
That's such a difficult situation to find yourself in. I think your first line of attack is to have a discussion with the partner, going into it, as I suggested, curious. Maybe you've misunderstood something, so let's give him or her the benefit of the doubt. Have that discussion. But if your concerns turn out to be well-founded, I think, especially as a junior associate, I would do two things. I would talk to somebody else at the firm more senior to you to get some advice. And I think I'd also reach out to LAWPRO on that. I think it has to, if there's been an ethical breach, you can't just sit with it, or the Law Society. I'd be worried you're now complicit because you're aware of it and you're not protecting the client's interest. So first, have the discussion, go into it with an open mind. Maybe there's something that could be corrected. Hopefully the lawyer was unaware he or she crossed an ethical line. Maybe there's a correction, and then LAWPRO obviously isn't the right way to go initially. But I would reach out to the Law Society, worried about being complicit yourself.
Okay, thank you, Deborah. And one more question for you. How does cultural competence relate to civility within an office? Specifically, civility can sometimes be influenced by race and cultural norms and people's backgrounds. And so what steps do you think the legal profession can take to ensure that these standards are inclusive and respectful of these diverse cultures?
Wow, that's a big question. And I suppose education really is the only way around that. because people from different cultures, what might feel like an abrupt way of dealing with you and perhaps borderline rude. Some, cultures, that's the norm. Others are far more nuanced in how they speak, and you may not understand the seriousness of the discussion because people are putting it to you in such a gentle, nuanced way. It's a big topic. And I think my only suggestion would be for folks listening in on this, if you're at a smaller firm and you know that you've got, hopefully you do, because it's Canada, have a cultural mix of folks here, do some reading, do what you can to self-educate on the cultural norms of the people that you work with, so that you're a little bit more aware of their comfort level communicating. If you're at a large firm, there are lots of people out there, I'm not one of them, who do education, and it's interesting stuff. I've done it myself, about how tone and it takes, a different form depending on culture. So, I think it would be interesting for all of us and certainly helpful in our interactions with each other. And that would flow through to our clients too, because it is Canada. So we're going to have a diversity of our clients as well. And knowing how they like to be communicated in with and how they speak to us and what it means for us to interpret it correctly.
Thank you, Deborah. I believe we have a couple more minutes, and so I have a couple of short questions for Sandra. So if Sandra could turn her camera on. The first question is phrased like this. I've heard people say that lawyers litigate aggressively or even rudely because it works, because they find they're more likely to get a better result that way. What are your thoughts on this kind of perception?
It's wrong. And they must have learned that from TV. I don't know. I was reading the questions as we were listening to Deborah answer her questions, and I was thinking about it. I think people are getting this perception, obviously, from TV or whatever. But the example I like to give to people when they say something like that is some of the best advocates I have ever seen in my 30 plus years in this business are the ones who are the very measured and non-aggressive type speakers in court. And the reason why they are so effective is because they instill this feeling of trust in the judge. The judge just looks at them, and lawyers, counsel on the other side, trust them, that they communicate in a way that instills that confidence. Aggressive people don't do that. Aggressive people have you on the sort of edge of your seat and getting ready to be defensive. The other example I give is, I was going to actually mention this in my talk, and so I'm glad the question was asked. Where you're in those really difficult negotiations, or even if you're having a difficulty with a judge, some of the best strategy that I learned from a senior lawyer when I was younger was moving the conversation or the submission so that it gets to the point where the person adverse to you thinks it was their idea, right? Like, oh, that's, it's really good that you raised that, and maybe the way to, get through this is to do X. But if you turn it around and make that person feel like, well, I'm kind of winning this because she's, accepting my idea, it's a very effective strategy. So instead of responding with, you're absolutely wrong, that's unjustified, blah, 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 you turn it around to try to convince them that this was really their idea in the first place. With respect to judge, obviously, it's a little bit different, but it's kind of the same approach.
Okay. And I think that takes us to the end of our time. Thank you so much to all of the panelists. Thank you to the TLA for helping us to host this program. And a reminder, there is a survey in the chat. If you could please click on it and fill it out, it'll help us know what to do in the future. And our next particular program is November 7th, where we're talking about marketing, management, and mentorship for lawyers. Thank you again for joining us, and I hope everyone has a wonderful